You have questions, we have answers. This is Jane Muller.
And this is Ken Muller. Welcome to our show, all about real estate with Ken and Jane. Today we have as our guest Jason Fruhschein. He's a partner with Fruhschein and Steward, located in North Brunswick, New Jersey. Jason, big welcome to our show.
Thank you, Ken. Thank you, Jane. It's great to be here today.
Yeah.
It's great to have you. So we're going to talk about estate planning in real estate. And before we get started on that topic, give us an overview of your law firm and what you guys do.
Okay, so the law firm is Fruhschein and Steward. We're located right in North Brunswick on Route 130. And we've been in practice together, Tuesday after Labor Day, it'll be start our 14th year.
Wow.
I've personally been practicing law for 31 years. And my partner, who happens to also be my wife, has been practicing law for, I'm going to get this wrong, 33 years, I think. I know she started a couple of years ahead of me.
You're trying to say she's older than you, right?
No, she's smarter than me. And our practice is very broad in that we're there to help people. So I do the transactional side of the practice. I do real estate. I do estate planning and wills and trusts, which unfortunately people pass away, so it leads to the estate administrations and the general business work. And then my partner, she handles the litigation. So, like as a quick example, we sometimes have cases where I'm doing the real estate transaction. There's a title problem. You need to get a judge to decide on something. She can handle that, and we can still get the transaction closed.
Right.
And if anyone wants to contact me, my phone number is 732-658-1200. Once again, we're right in North Brunswick, and we're here to help people.
Yeah.
Great.
And it's advantageous to have a firm that does both estate planning and real estate because they often go hand in hand. Unfortunately, people die and they leave behind real estate, so estate planning and real estate are locked together, and that's what we're going to focus on this show, and you're going to come back next week, and we're going to do part 2. But for part 1, we just want to get into the estate administration and talk about when somebody passes away that owns real estate, on what are the possible scenarios. You can talk about whether they die intestate, without a will, or if they have a will, or if they have a trust. There's different scenarios that could arise.
Of course. So when someone dies, they own property, whether it's owned by them directly, whether it's owned in a trust. And if it's owned by them directly, then you're going to deal with the surrogate to get the authority to transfer the property. The surrogate will deal with a will. If the person drafted a will, that will be the directions what to do with their assets, including the real estate. If they didn't have a will, there is basically a state-provided will. It's called intestate distribution. And in a nutshell, it's going to leave your assets to your closest living relatives. It'll look to children first, children and spouses. If you don't have either, then it can go up to parents, then start going to brothers and sisters. That is not the preferred way to do it because the state is guessing which way you'd want your assets to go. So it's always better to have a will just because it gives a clear direction. The other way property is owned, in a piece of real estate, you can have a husband and wife, and they can own it tenants by the entirety. Mm-hmm. So when that person dies, the survivor already owns the house. There's nothing that has to be done with the surrogate. Yeah. Technically, you can also have joint tenants with rights of survivorship. Jane and I could own a piece of property together, joint tenants with rights of survivorship. I won't knock Jane off. So if I die, Jane would own the property 100%, right. And that's joint tenants with rights of survivorship.
And the deed would have to say that, right? In the deed, it would have to have that specific language. Like if Jason and Jane own a property that's deeded with that way, as you guys as the grantees, it would have to say with joint rights of survivorship. Otherwise, it would be presumed that you would be tenants in common, right?
That is correct. The law presumes that it would pass through your will, not have this right of survivorship. And then the last way, as we were talking about how property can be owned, you might have a trust. So your assets and that real estate may already be in a trust when you pass away. And if that's the case, similar to a will, it's a set of written directions, who's in charge, and what to do with the assets. And those are the various different ways that, when someone dies, what happens with their property.
Right. Now, if the property is in a trust, though, that avoids having to go to deal with the surrogate or having to go to probate, which is if you right, you don't have to involve the surrogate or the county law office at all.
That's correct. It avoids needing the surrogate's approval for the will and the appointment of, it's usually a person called an executor in a will to deal with the final affairs of the person's estate, including, selling the real estate, transferring it if it's not being sold to whoever it's supposed to go to. With a trust, the real estate would already be owned by the trust. And therefore, you don't go to the surrogate. The trust would just say, let's assume, John Smith's trust, when he dies, it says, upon my death, my daughter Jane Smith is the trustee. So John dies. At that point, Jane Smith becomes a trustee. She's now in charge without any appointment papers other than producing a death certificate, maybe signing one or two documents that can be created in our office if somebody's looking for that.
Right.
One question I have: if the property is not in the trust, but the person had a will, surrogate in in New Jersey is pretty fast, right?
Well, I think there's a certain amount of time you have to wait, but and every county has a surrogate, and then you have to go through a process like
maybe
Jason can better explain.
Yeah.
You have to wait a certain amount of time. Then I think whoever the executor of the will is has to go there with the original will document, and then with the death certificates, and then they have to fill out papers, and you have to, I guess, probate is like proving the will, so you have to maybe advertise it and make sure that that is truly the last. That, as I understand it, but Justin,
I'll say it this way. So, yes, you have to go to the surrogate. There are 21 counties, and every county has their own surrogate. Every office works a little differently. I live in Middlesex County, and I'm going to give props to Clarabelle Cortez, the Middlesex County surrogate. They do a great job of it.
Yeah, that's why I thought
And so it is fast.
Yeah.
When you send something there, it works quickly. In the post-COVID world, we do a lot more stuff online or through computers. So instead of necessarily having an appointment with the surrogate, we can prepare the papers in our office. We will scan and email the will, the death certificate, and a notice sheet to the surrogate. They'll prepare everything, and then we have a choice. The client can go to the surrogate in New Brunswick, or the surrogate will mail the papers to my office. Client can come into our office. We could sign everything, send it back. Oh. It goes quickly. Now, you did make the point about the time delay. Yes, that is true. The law in New Jersey says you cannot probate a will for the first 10 days after date of death. Mm-hmm. It allows people to file something called a caveat, which is basically an objection to the will. Mm-hmm. But 10 days is not that long of a period of time. And here's my conversation with someone. When I get a phone call from someone, Dad passed away, what do we do? When did they pass? Oh, yesterday. I'm going to say to the family, here's what you need to do. Make your funeral arrangements, deal with the family, deal with that stuff.
Sure.
Don't worry about the will because we need 10 days anyway.
Yeah.
Let's make an appointment, have you come in next week, and then we can get off and running at that point. But deal with the emotions right now.
Yeah.
That stuff can wait a few days, and then we'll get you through that process.
Yeah.
Right. Now, there's a lot of talk today about like the advantages of a trust, but a trust aren't necessarily a tool that everyone needs, right? It's not. I mean, a will, like we said, the process in New Jersey, at least in Middlesex County, is pretty fluid in getting the will process, and a trust is a legal instrument that some people may want to consider based on the assets and based on, but it's not. But I guess that's what your firm, you would look at the particular facts of the individual or the family to determine what instrument is the best to protect them, right?
That's correct. And we'll have that consultation with the client. We'll talk to them. We do not charge for that initial consultation. We feel it's important for us to get an understanding of what the client's looking for, what their facts and circumstances are. And they also have to figure out if they're comfortable working with us. I will say most people are, but I'm not pushy. I'm not going to push someone to say, you got to sign on the dotted line this second. So we'll have that consultation, and then we'll make recommendations. And we'll say to someone, here is your goal. Here are 2 different ways to get there. And we could do a will, we could do a trust. And we'll talk about the pros and cons of both. And I'll give you an example. If someone walks in the office and they say to me, okay, we own a house in New Jersey, we have these other assets, but we love to ski, and we also have a vacation place up in Vermont to go skiing in the winter. Well, at that point, I'm going to say to them, you probably want to have a trust, because probate in New Jersey is not complicated and it's not expensive, but you would have to probate not only in New Jersey, but then you do something called an ancillary probate in Vermont. So now you're doing a second probate, because the real estate is governed by the laws of the state. Your personal assets, you can have a bank account in Vermont, but that would still be a New Jersey asset for probate purposes. But real estate is wherever that ground is the state that's going to govern it. So we will do a trust to avoid probate, which is the main goal of avoiding, of using that trust. It's just if you only own real estate in New Jersey, you have to consider, is it worth avoiding? What's the benefit of that?
Right. What is the benefit, or what's the tax avoidance? And we could spend a whole show talking about that, which is beyond the scope of this.
Exactly.
We just want to talk about.
And I'll tie you into a real estate issue with that.
Yeah.
So let's say we put husband and wife into a living trust, and they own a property in New Jersey. And then they decide, you know what, we're going to downsize. We're going to sell the big house that we raised the kids in, and we want to downsize into something smaller. But that property's in a trust. When we're selling the property, we have to now take the property out of, assuming they were 62 or over, we have to take that property out of the trust, put it back in their own individual names to then sell it as individuals, so we can get a benefit of, there's a realty transfer fee in New Jersey, but you get a discount if you're over 62.
Right.
And you don't get that if it's owned by the trust.
Interesting.
So we've done that where we do the double deeds. And obviously there's a cost to doing the double deeds. So I always like to lay these things out for the client so they can do the cost-benefit analysis of what they want to do. And that's really the purpose of, why we do free consultations and why we're willing to get on the phone and talk to our clients as opposed to
I have a question before the break.
Before the break, about 2 minutes before we go to break.
I have a quick question. Say, if the house, like you said, the couple in the living trust, right? How that affect if you use regular home, if you live there more than 2 years, and when you sell, a couple up to $500,000.
Oh, she's trying to say, how does a trust affect the principal residence exemption having lived there 2 of the 5 years? If it's in a trust, what is the tax?
You can still claim it. It doesn't hurt you because
good.
the type.
That's a good question, though. Yeah.
Just to be clear, it depends on the type of trust you're using. But let's assume we're using what we would call a living trust, or the one that can change. The IRS looks at that as if that doesn't even exist. You're not even filing a separate tax return. You're putting everything on your same 1040, your income from everything in the trust. So you don't lose your $500,000 exemption or $250 per person. We still get the benefit of that, even if it's in the trust. But if you're over 62, I'm going to take it out of the trust because on a picking a $600,000 house, I'll probably save a client $3,000 taking it out of the trust.
If it's $1 million, most
that's a very
likely
good
there'll
question.
be much
I never
more.
thought about that in the trust and the implications.
But if there's a if the
irrevocable trust, well, that might be a whole other.
And then it'll be different.
Might be a whole different.
That would be different. But then you've also put it in that trust that you cannot change, an irrevocable trust. Then there's a reason for that, whether it's a tax reason, whether you're doing some Medicaid planning or something along those lines. And then that's the cost. When it's being sold, you're not going to get that benefit.
But there's other advantages which are beyond the scope of this discussion. I'm sure they have a good reason for it that a lot of the wealthy people do that.
And that's why we do these initial
that's why
consultations.
Give your number one last time. We're going to go to break.
It's 732-658-1200. I'm at extension 1, and feel free to call with any questions.
All right, thank you. All right, very good. We're going to take a quick break. We'll be right back after these messages. Okay, welcome back to our show. We're joined today by attorney Jason Fruhschein, a partner with Fruhschein & Steward, located right here in North Brunswick, New Jersey. So we spoke about the differences of the will and the trust and how complicated it can be. There's a lot of things, and we highly recommend anyone out there, listener, this is just general legal advice. If you definitely should consult, give Jason a call. If you have specific needs for a will, a trust, there's also, I'm sure you guys do health care directives. That's powers of attorney. That's all tied into it. And it's great. His firm is great because they do the estate planning and also your real estate, which go hand in hand. So So
and
let's
they gave a first consultation is free,
free.
right?
Yeah.
So
correct.
you can't go wrong with that.
Yeah.
So you should really
really-
talk to the professionals before you do anything. Yeah,
Yeah.
or not doing anything.
Yeah.
Just you should really consult. Yeah.
Absolutely, yeah. So let's talk about now, if you're dealing with an estate property, who has the authority to sell it? Obviously, this is assuming the husband and wife, it's not a tenants by the entirety where the husband or the wife is alive after the spouse is deceased. But let's say you're dealing with like the parents, and then the remaining parent is deceased. The executor happens to be one of the surviving children. There might be, let's say, 4 kids, and let's say Sue is the executor in that case, or you're dealing with a trust. How does a trust set up? Who has the authority to actually sign the listing agreement for the real estate agent, and also the conveyance documents when you get to that point?
Okay, so let's talk about if it's in a trust. If it's in a trust, and let's say Sue is the trustee, she has the authority. As the trustee, she has the authority. Now, we want to make sure there's some language in the trust that authorizes the sale of real estate, but typically it will. And so she can sign the listing agreement. It will be sold, under the name of Sue, trustee of the such and such trust. And, all that is worked out with the title company, with the buyer. We'll provide either a copy of the trust, or sometimes we won't give the whole trust. We'll give something called a certificate of trust, which just gives the pertinent details that they need for the sale of the property. A will becomes an extra step in there. Mm-hmm. So someone dies, they have a will, you probate that will, and we talked about that earlier, and now Sue is appointed as the executor. So now Sue as the executor has the ability to sign the listing agreement, sign all the closing documents, make all the decisions, because as you both know, in real estate deals, decisions come up along the way. Somebody does an inspection and you have to either repair something or offer a credit. Sue gets to make that final decision. The trick of it all is when there are multiple beneficiaries.
Correct.
How do you deal with that?
That was my next. You led into my next question, right? And we're going to talk about that, and then we're going to talk about if there's co-executors, which I think Jane has an interesting story. That can also be. Those are both challenging. Let's do one topic at a time. Let's talk about in the example with Sue. Let's assume she has 3 siblings. We'll say 3 other sisters. We'll make them all blame it all on the women.
That's not fair.
Now there's a house, and that comes up first. Comes the price, and obviously, assuming the will or the trust gave her the authority to sell the real estate at 123 Main Street in Middlesex County, USA. Now comes up the list price, and then dealing with the multiple heirs. I mean, your phone might get calls from the brothers or let's say her sisters that are saying we don't agree with the pricing, we don't agree with the home inspection. So how do we deal with all that?
Well, at the end of the day, Sue as the executor gets to make those decisions. But Sue is a fiduciary. She has an obligation to all of the beneficiaries of the estate, she being one of them and her 3 sisters being the other beneficiaries. So she has to act in good faith. She has to make good decisions. So Sue talks to the 2 of you, says she wants to sell this house at 123 Main Street, and you say to her, this house is worth $600,000. Well, she can't then just say, all right, let's sell it for $400,000 to my friend. Because then you're not acting in the best interest of everybody.
Or my son.
Or
her son, right? And then
exactly.
And then,
but if she's acting in everybody's best interest and she's getting the guidance of other professionals like the 2 of you as to what the value is, she puts it on the open market so that you can have multiple people look at it and make offers. Now you're getting the fair market value. So there's less ability for the other sisters to argue. Having said that, I've had estates where people decide that they're going to fight about something in the estate because now that's the opportunity to get back at the sister from something that happened 10 years earlier.
Oh my
so
God.
You can never control that.
Right, because you don't know the family dynamics, right?
Exactly. But I was just going to say that's what the courts are for, because Sue's going to do the right thing. She's going to list the property at the right price. She's going to sell it for a fair value. She's not doing anything wrong. But if one of her sisters says that's a problem, there are 2 places that sister can object. She can object before it's sold, and she could say to Sue, I think this is wrong, and they'll kind of discuss it. Mm-hmm. If they can't have an agreement, one of the sisters can go to court. The other sister, we'll call her Debbie. She can take Sue to court saying you're underselling the property. Or Sue could actually go to court to get a ruling from a judge that it's okay to list the property for a particular price. And as long as you get that number, and we do that in guardianship cases because now the court is already involved in the guardianship, you need court approval to sell a house. Right. So you could do that. The other place it could be figured out is the house is sold. We're now several months down the road, and now Sue wants to make distributions to her 3 sisters. Yeah. Here's what I started with. I sold the house. We moved this money from the bank here. We paid the funeral bills. Here's what's left. Everybody gets 25%. Okay. And now Debbie says, oh, no, I don't agree with those numbers. And they're going to fight there, and she won't sign off on it. Again, you're going to wind up in court if you can't reach an agreement because that is the place that you arbitrate these disputes.
And it's going to drain money from the estate. So at the end of the day, you're going to go to court and you're going to argue about it, but you're going to burn attorney fees and litigation expense. Correct. So it all comes out of the estate.
What I recommend for clients, and when an estate is in my office and maybe I'm only dealing with the executor, not the other 3 sisters, I will tell them, make sure you communicate. Yeah. Communicate with your siblings, with your heirs. Let them know what's going on because the more they know, the better off they're going to feel, the better chance there is that you're not going to have a dispute because they feel like they're part of the process. Even though you're the only one signing papers, they're a part of the process. Talk to them. When if one sister says, hey, I got a really good person who wants to buy this house, you could say, okay, that's fine. We don't even have to put it on the market, but let's then get an appraisal to make sure that that's the fair value. Or, they want to buy it. That's okay. We can list it with a realtor. We can do a carve out where if this person buys it, maybe there's some adjustment in the commissions because you're bringing that person to the table. But then at least you got fair value, so you're not selling a $600,000 house for $400,000. Right. And it's fair to everybody. Communication's the key.
Right. Likewise with the home inspection, that's going to be an issue where they're going to say, oh, we're giving them $10,000. I'm sure that comes up oftentimes if the brothers and sisters are remotely located and they think that that's a lot of money. But if they don't understand the issues and what came up, maybe there's an issue with the sewer pipe that needs to be replaced. There might be mold.
More and more there might be
a water infiltration, mold. So that adds up everything. So $10,000 may be very reasonable. But if you don't communicate with them, then they have no way. They're looking at it from a telescope, somewhere they might be in Utah or somewhere, and to them that's a lot. Might be seem very expensive, where in fact it's not.
And I'll give you the interesting scenario. Let's reverse that. You have the executor in Utah, but the other beneficiary lives locally. Now the executor is the one signing everything, but it's a good family, and so the one sister that lives locally, she's the one running around and doing everything. Yeah. So again, communication is key. If everybody's on the same page, everything is going to go smoothly. But sometimes you can't do that, and then you try and work through the issues, and if you can't, ultimately you wind up in front of a judge, and then the judge says, this is the way we're going to go.
Yeah,
right.
Absolutely.
Now let's flip it, and what if you have multiple co-executors, which, that could be a whole topic. Do you recommend, if you're doing a will, I guess we're talking about, to have 2 executors, co-executors as they're referred to, which Jane you had a situation a few years ago, and it proved to be quite challenging. Because the brother and sister were co-executors on a house, and they weren't on speaking terms. The brother was living in the house, but his sister living in the West somewhere was a co-executor, and it proved very challenging to the whole process.
Yeah, they each hired an attorney.
Yeah.
Fight out in court. 3 years. 3 years.
It happens. I recommend to clients, pick one executor. The key component for me for an executor is you want someone honest and trustworthy. If they're honest, they're not going to cheat anyone. If they're trustworthy, they're doing the right things. They don't have to be savvy. They don't have to be a financial wizard. That's what you hire accountants for, attorneys. When you're selling a house, as smart as I think I am, I'm hiring a realtor because I don't know everything. I don't know. I think I know what my house is worth, but you two could tell me what my house is worth. We kind of stay in our lanes, and it's just smarter to do that. when you have multiple executors, you have multiple opinions. My worst
That's true.
was about 20 years ago. I had 4 executors.
Oh my God.
They did not all like each other. There was multiple attorneys involved. We were in court, and it was a large estate, so we wound up filing estate tax returns, and you needed to have approvals from everybody. And the funny thing was, the one sister who was difficult and objecting to everything and brought the extra attorney in, she had a set dollar amount in the will. So it wasn't even a percentage. It did not matter, but she just liked to stir the pot. And it just became very, very difficult. So, yeah, I always recommend to people, one executor, don't use a will and appointing executors. Don't think that's the way to get your kids that don't get along as well, getting them back together. That's not the place to do it.
It's not going to work.
Yeah.
It's make it worse. And in my case, was the parents only have 2 kids, son and daughter. So they made both executor. And then they don't agree with each other on anything. They both hired an attorney. They went to court 3 years. At the end, the sister living in Las Vegas find a realtor. The brother refused entry, and the brother hired me, and then they disagree. And then at the end, the lawyer found out, called me up, and realized I never met brother. He just hired me because the house is in East Brunswick. So he know my name. When the sister realized I do not know them, and they hired me. Because
or they conceded.
I didn't know. I didn't know either party basically, but they want to make sure I'm gonna be fair. So yeah, I got hired.
And you should have the best interest of both parties because you want to get the maximum value.
And you work for both parties.
Yeah, so absolutely,
you know?
they should have the.
You
they
work
should
for
have
the
a great,
estate. That's your job.
They should want a great realtor.
But they wanted me. But the first impression they said, oh, he's a realtor. I don't agree. He will say her realtor. I don't agree. At the end, when the sister's lawyer was very nice from Red Bank, called me up, realized I don't know them. I don't even know I'm gonna get a listing. So and then they said, okay, you're fair. That's good.
Jane, you were neutral like Switzerland.
Right, there you go. That's great. Right.
Yeah.
So we have 1 minute left. We want to thank you, Jason, for taking time out of your busy schedule to join us this Sunday morning. Please give your contact information again for our listener base out there. And also, do you do estate tax filings too, or is that mostly the accountant does that?
We will work.
You can work with the accountant.
We will work with the accountant, and then it'll become the client's choice. Sometimes we'll do it. Sometimes we'll have the accountant do it.
Okay.
And we'll review what the accountant's doing. We work together to get it. It's a team effort.
It's a team effort, and you're the one-stop shop for the estate planning, real estate, and your wife handles the litigation if God willing, God forbid you need it.
Which is why I don't win any arguments at home.
Oh, right. That's a good point.
Yes, dear.
That's why you have to learn how to say, right.
Ken, Jane, thank you so much for inviting me today. I appreciate it. And to the listening audience, if I can help anyone, please give us a call at 732-658-1200.
All right. We hope you guys enjoyed the show. Have a great rest of the weekend.
Thank you.